Hey everybody, this is John Skiba here, and in this video we're going to do things a little bit different today. It's a Saturday morning, I'm in the office trying to catch up on a little bit of work. I thought I would do a quick video that maybe, in the words of Simon Cowell, it would be a little self-indulgent. And that is to share with you why it is I do what I do, why I have the Consumer Warrior YouTube channel, why I take the time each week in putting out all this information, and why I think it's so vital that there are people like you and attorneys like me that fight back against junk debt buyers. But if this is your first time here to my YouTube channel, please go ahead and click subscribe, check off that little bell. That way you'll be notified each and every week when I put out a new video that'll help you deal with your serious debt problem. All right, let's talk about really the Consumer Warrior brand, the Consumer Warrior YouTube channel, junk debt buyers, why in the world I do this, why I spend so much time trying to educate people on what some of their rights and strategies and approaches are to dealing with junk debt buyers in particular, and really how all this came about. You know, I always say when I'm a little kid, no one, imagines growing up to be a bankruptcy lawyer. I mean, that wasn't in my list of hopeful careers that I was going to have. But what got me kind of thinking about it is earlier this week I had a couple hearings. Now sometimes I'll get clients who will ask, why do you do this, or how did you get into this? But sometimes I have even judges and opposing counsel ask me, what are you doing? Why are you doing this? I had a hearing before a bankruptcy judge this week, and he basically was a little bit condescending to the arguments because I had objected to some claims that were brought by a junk debt buyer, and really just acting as if, why are you doing this? Why is this even legitimate for you to raise these objections, even though these claims had no supporting documentation? It was in bankruptcy court, but it was the same old thing that we always deal with when it comes to junk debt buyers, is there was just very little information, very little documentation. I had another instance where I sent notice that I'd like to take a deposition of one of the employees of the junk debt buyer. And the opposing attorney got back to me and said, why are we doing this? Why would you do this? Why is there any need for you to go through this process? As if, that I've insulted them by merely asking them to go through the process. They filed the lawsuit. They should have expected that there was a possibility that someone's going to push back and want some information before they just write them a check. Not only that, they offer to the ones who are not providing the information. They come with these lawsuits with very little documentation, very little information, and then they're surprised when people contest that and want to fight against that. So those are kind of the things that we deal with on a daily basis. How I got into dealing with junk debt buyers, because there's very few attorneys that do. Surprisingly, we've talked about before, junk debt buyers like Midland Funding, Portfolio Recovery, they file on average more than 500,000 lawsuits a year in the United States. I mean, that's huge. For most smaller courts, justice courts, small claims courts, these are second only to criminal cases that come through the courts. And some, it probably overwhelms their case beyond criminal cases. The courts see these a lot, and there's very few attorneys that deal with it. Less than 1% of people who get sued by a junk debt buyer retain an attorney to help them. That's often because the amount in dispute isn't high enough, or obviously there's some financial hardship and it gets expensive to hire attorneys. So how I came about these cases, because in Arizona I think there's 3 of us in the whole state that defend consumers against credit card companies and junk debt buyers. How I did it, my background was always in bankruptcy. Even in law school, I like bankruptcy. I was privileged to go to UNLV Law School, where my professor, my bankruptcy professor, was a guy named Bruce Markell. And he actually literally wrote the book. He wrote a lot of one of these big treatises called Collier's on Bankruptcy, which is kind of the preeminent treatise on bankruptcy. He was also involved in the drafting of the revised bankruptcy code. And as weird as it is, he made bankruptcy super interesting to me while I was in law school. And so when I started practicing, I always had bankruptcy as a component of my practice. For a while, it really drifted to almost exclusively bankruptcy. But I noticed something when clients would come into my office, that there were all the time I was running into situations where they were being sued by Midland Funding, or they're being sued by Unifund. And the suit would be $7,000 to $10,000, and they're saying, hey, I better file bankruptcy. I can't get a judgment. I can't have my wages garnished. And often they didn't have a whole lot of their debt issues. And so it kind of put me in this weird spot where, a bankruptcy will solve that problem, but it's going to cause a host of other problems. It stays on your credit for 10 years. It's going to make lending difficult in the next few years. And so I was looking for different alternatives other than just pushing these people into a bankruptcy that I wasn't sure they needed. So I started defending some. The first one I defended was a Midland Funding lawsuit. I thought, let's file an answer to it. And I started researching some of the strategies, and I actually found this book here, Collection Actions by the National Consumer Law Center. This book is awesome. This book taught me most of the strategies that I use even today. It's not light reading. You can see this is what every single one of the pages looks like. It's very comprehensive. The people at the National Consumer Law Center are great, very detail oriented, and I just spent a ton of time reading and researching and understanding what the defenses were, what the problems were. I remember the first time I read that book, I was reading through all the deficiencies, maybe like the bill of sale on a debt collector's case, and saying, that the bill of sale will say, hey, we're selling all these accounts, they're listed on Exhibit A. And then I read in the book and it said, then you'll turn over and Exhibit A will be blank. And I thought, there's no way that's true. And so I pulled up some of my bankruptcy cases and I was looking at some of the documents. I'm like, it is true. They haven't attached anything. And so I started to contest these and we started winning a lot of these cases. And so that kind of just, snowballed from there. I wrote a few blog articles for my law firm's website over at consumerwarrior.com and on Midland Funding. For a few years, I was #1 in the world when you searched Midland Funding. I literally got mail that was addressed to Midland Funding to me because people were just Googling it and sending it to my office thinking that I was Midland Funding. I would have people call me and ask me, consumers, why are you suing me? And I'm like, hey, I'm actually helping to defend consumers against Midland Funding. So I made some changes to my website when I realized people were doing that. So that's kind of how I got started in it. My background has always been one where I didn't like the bullies. I always felt like this was kind of a bullying thing. I mentioned before on the YouTube channel here, I played college football at BYU. And I think that influences, that kind of competitive desire that I had. I always loved football, the battle that it is in a football game. There was a little bit of that. I think that helped me to really kind of like these because it was kind of a challenge to be able to push back against these debt buyers and try to win these cases for my clients. There was probably an element of, I played offensive line. And so the offensive line, it's baked into us that we're the protectors. You're there to protect the quarterback and the running back. There to really kind of push people out of the way to help others. And I think that was really baked into me as well, that it was making a difference. People weren't having to file bankruptcy and just destroy their life financially, but they could deal with this junk debt buyer lawsuit in a way that would resolve it and allow them to move on with life and not have this thing, just hanging on forever. Because there's so many times too, even today, I see cases with junk debt buyers where it blows my mind. They'll get a judgment 10 years ago for $4,000, and then the things have been churning interest at 29%, and then they're trying to collect $20,000 and garnish wages on 20 grand for a debt that they probably paid a few $100 for. There's something just inherently inequitable about that. And so those are the types of things that I think are really motivate me to continue on in this practice. There's another element as well, just having a level playing field. I often compare what I do to defense attorneys, criminal defense attorneys. A lot of people say, how could they do that? How could they represent that criminal, that murderer, whatever it is? And for a while, I actually served as a county prosecutor here in Maricopa County with a huge office. I think it's like the 5th largest prosecutor office in the United States. And so, I kind of got to see a little bit of that, but it also kind of exposed me to the fact that one side, in the criminal justice system or just in the legal system in general, it's dangerous when one side has too much power, if there's not some kind of counterbalance on the other side. And so in the criminal justice system, obviously, they feel that it's so important that if you can't afford an attorney, they actually appoint one for you. It's important that you have someone there to protect your rights and to hold the state in check. Unfortunately, in the civil world, there's nothing like that. And so what I've seen is in the debt collection area, the creditors, the collectors, the debt buyers, they're almost always, and they're always represented by attorneys. They have lawyers in there, and then on the other side, you have 95% plus, actually it's like almost 99% plus of people who are representing themselves. So it's not really a fair fight. You've got someone in there who does this all day professionally for a living. They've gone to law school, they've passed the bar, they know the law, they know the courts, and going against someone who doesn't have any of that background and doesn't have any of that training. And that's when you see this, just the system gets out of whack. It gets out of balance. And that's why you start to see, and particularly, a lot of different states, you see just crazy rulings and things are just unfair. It feels like judges sometimes are not looking at the evidence on a case-by-case basis. There just gets to be a feeling of, hey, everybody here is liable. Let's just keep these things going and hopefully we won't clog up the courthouse with them, kind of thing. So I think it's important that attorneys and people like you that are defending these suits, that you press back against the debt buyers. You've got to do it in an honest and an ethical way, but the burden of proof is on them. And I always take the position, if they're going to file a suit and they want a judgment stands for something. It's one thing for them to come in and say, hey, there's a debt that's owed and you need to pay it. Here's a letter, we're going to call you, we're going to try to collect on it. To me, it's a whole nother thing for them to come in and get a judgment. A judgment stands for the position that they have done all that's necessary. They've proven that by a preponderance of the evidence that there was a debt owed, that this specific account was transferred to that entity, and they've proven the exact dollar amount that's owed. If they can't do that, courts should not be signing off on that. This is my opinion. Because that's what all of the procedural rules, the rules of evidence, those are all in place to make sure that all of the best information and best evidence is presented to the court, so that that judgment, which gives them a ton of power. In most states, they can garnish your paychecks, they can garnish your bank accounts, they can lien your home, they can do all kinds of really horrible things. They shouldn't have that power unless they've taken all those necessary steps. So that's kind of the backstory of why it is I do what I do. I think it's important. I do the YouTube channel. There's two reasons. There's obviously some benefit to me. People call me and hire me that live in the state of Arizona because this is a form of advertising. But I also know that the principles that I talk about are often universal from state to state. And there's those people who are out there getting sued by a Midland Funding for $500 that don't know what to do. They're losing sleep over this. And this can provide you some information to at least understand your options, to alleviate some of that stress and to put a plan on how to deal with it. And I can tell you, most of these cases settle. The debt buyers end up getting some type of payment out of it. The goal, though, is to make sure that you protect yourself and assert your rights that you have in this case while you're trying to reach a resolution that'll work for both parties. So kind of a different little video today. Hopefully that's interesting or beneficial to all of you who support the channel. I really do appreciate all of you who support it. We're closing in on 10,000 subscribers. In 2020, it's grown way bigger than I ever thought it would be. I appreciate all you who comment and check in with each new video. If you haven't subscribed, go ahead and check off here on the screen right now. But I appreciate you watching today. We'll check you next time.